Hello and welcome to yet another episode of the new series. My name is Pooja Dwivedi. Today we are going to discuss a very important topic from the perspective of your preliminary polity and also from the perspective of GS Mains Paper 2nd. So, Supreme Court is going to review a 30-decade-old judgment which bars police custody beyond 15 days. It is possible that the 30-decade-old this judgment was pronounced by a two-judge bench. The current case also has the pronouncement by two-judge bench. So it is possible that it is going to be passed on to a larger bench. Moving on, let us first of all discuss what is the background. The Apex Court has said that its existing position on whether an accused can be detained in police custody beyond a period of 15 days from the initial date of arrest, it needs a review. And this has been said by a bench of justice, bench comprising of justices M.R. Shah and C.T. Ravi Kumar. And they are saying that the court needs to review a landmark judgment of 1992. And in that only, they are saying that this particular judgment said that no detention in police custody beyond the first 15 days arrest is permissible. Moving ahead, now what's the current case about? Let's know about that. The CBI has moved to the Supreme Court for seeking additional custody of an accused by the name of Vikas Mishra. Vikas faces charges under the Prevention of Corruption Act for the breach of trust and conspiracy, and he was remanded to CBI custody for a period of 7 days from 16 April 2021. So this is the entire scenario that we are going to talk about. Now the problem here is that the basic premise, why should this 15 days of time restriction should be there? In order to ensure that CBI and other very important organizations which are dealing with such detention, they complete their investigation within a stipulated time. This is the basic premise of it. However, Vikas was hospitalized after 2.5 days in custody and he was later on granted bail. His bail was later cancelled and he was in judicial custody before being granted the bail again. Okay, so this is the entire matter. CBI has required that there should be a fresh custody of Vikas since he couldn't be interrogated by the CBI earlier because he was hospitalized. Now, Vikas's lawyer is saying that this fresh demand is not permissible because police custody, which shall be beyond the period of 15 days from the date of initial arrest, is not possible. CBI versus 𝐈𝐀𝐒 𝐏𝐫𝐞𝐬. This is a very important case of 1992 that we were talking about. In here, the Apex Court said that an accused cannot be detained in police custody after the lapse of 15 days from the date of arrest. So remember all these points. Moving on. In the current case, the court eventually has granted 4 days of police custody to the CBI and said that in the light of aforesaid facts and circumstances, there is an observation that has been made by the learned special judge. While cancelling the interim bail, the decision of this court in the case of 𝐈𝐀𝐒 𝐏𝐫𝐞𝐬 is required to be considered. So this is the landmark judgment that we are talking about, which needs a review. Now, what does the law generally say about such detention? See, although magistrates mechanically, they grant police custody in virtually every case, but the law allows the police detention only in special circumstances, okay, because right to life and liberty is enshrined in Article 21 of the Constitution. Police custody is granted by a magistrate for reasons that must be recorded in the order, and Section 167 Code of Criminal Procedure has a provision. This provision is saying that procedure when an investigation cannot be completed in 24 hours. Okay, this means that detention beyond 24 hours is an exception. Moving on. Now, according to Section 167 Clause 2 of the CRPC, this provides power to the magistrate to authorize the detention of an accused in such custody as magistrates think fit for a term not exceeding 15 days in the whole. And what is this? The premise about it is that it is intended to protect the accused from the methods which may be adopted by some overzealous and unscrupulous police officers. So it is a power that it is kind of a, you can say, a blanket hold which has been given to the accused against the state machinery. Moving on, now a complete reading of Section 167 of the CRPC, it shows that after the 15-day police custody, further remand during the period of the investigation, it can be applied only in judicial cases. Judicial custody is in a central jail under the supervision of a magistrate. This is the next condition. Whereas police custody would be at police station for the officers to interrogate an accused. The law is a check on the state's power to restrict an individual's liberty. So when the police knows that they have only 15 days, they will try to complete the investigation within this period. However, this is routinely circumvented and this is generally not followed. The 15-day bar doesn't apply in cases if the accused is involved in a different case arising out of separate cause of action. Then even if he is in the judicial custody in one case, he can be formally arrested in the other case and the police can seek the custody again, which is starting another 15 days. Now, in the case of Alt News co-founder Mohammed Zubair, multiple FIRs were filed and this was done in order to continue the 15-day cycle, but he was granted bail by the Apex Court in July last year, holding that there is no justification to keep him in such a long custody continuously. The CRPC allows an accused to be released on bail also if the investigation isn't completed within the prescribed number of days. And this is generally referred to as default bail or statutory bail. The first limit is 24 hours. Then this can be extended by the magistrate for a maximum of 15 days. Remember the word maximum. Also, section 167, clause 2, subclause A, it allows the magistrate to authorize the detention of an accused person, otherwise in the custody of police beyond the period of 15 days if there is a satisfaction that adequate grounds are existing. However, this cannot exceed 60 to 90 days limit. Essentially, it is saying that further detention of an accused, it becomes very necessary to complete the investigation. The magistrate may authorize it, but it shouldn't go beyond 90 days for offences which are punishable with death or for life imprisonment and 60 days for other offences. Okay, remember all these conditions. Now, in its 1975 ruling, the Apex Court in the Matabar Parida versus State of Odisha held that if it is not possible to complete the investigation in the stipulated time, like that is 60 to 90 day period, then even in serious and ghastly types of crime, the accused is entitled to bail or a release. Okay, so I hope you understood this topic well. That is it. Thank you so much for watching.